Allow me to briefly recount how we came to this point. The matters we have been examining go to the very heart of the public's ability to rely on the integrity of our legal system, and we've been working diligently to get to the truth. We've encountered some obstacles, and we're working to overcome them. We've been working closely with our minority members in all of these efforts, and we deeply appreciate their support in that regard. We have a subpoena pending with the Justice Department for emails and related information, which the Department has thus far only partially complied with, but we continue to be in discussions with the Department regarding their compliance. We've requested interviews with a number of current and former high-level Department officials, and those interviews are being scheduled and conducted. We've asked the White House for information and for interviews with selected current and former White House officials who appear, based on information we've obtained thus far, to be significantly involved in the decision-making. As of yet, the White House has not been forthcoming, but we continue to hope and expect that we will reach an accommodation with them. It's against this backdrop that we consider Monica Goodling recently resigned from her position as senior counsel to the Attorney General. Among her duties in that position was serving as the Justice Department's principal liaison with the White House. She was apparently involved in crucial discussions over a 2-year period with senior White House aides and with other senior justice officials, in which the termination list was developed, refined, and finalized. She was also apparently in the small group of senior justice lawyers who prepared Deputy Attorney General Paul McNulty and his principal associate, William Moschella, for congressional testimony that we believe inaccurately portrayed the surrounding circumstances. And so Ms. Goodling appears to be a key witness for us as to any possible undue or improper interference and as to any internal discussions as to how forthcoming to be in Congress. But she's notified the committee, of course, that she would invoke her Fifth Amendment privilege against self-incrimination were she called to testify. And I don't think at this point that all of her potential grounds for invoking the privilege can be dismissed out of hand. So under these circumstances, it would appear that the committee has exhausted all reasonable efforts to obtain Ms. Goodling's critical information, short of providing her with limited use immunity under the applicable statute 18 U.S.C. 6005. Taking this step will compel her to testify under penalty of contempt, but under the protection that information she provides to us under compulsion could not be used against her for any prosecution, provided as long as the information is truthful. Under the statute, we direct the House General Counsel to apply to the court for an order conferring use immunity. The statute provides for notice to the Department of Justice and a waiting period so that the Department can advise the committee as to whether conferring immunity on Ms. Goodling would interfere with any ongoing or expected criminal investigation involving her. We will certainly take any concerns the Department may choose to provide us into account. As committee chairman, may I again assure all the members that I do not propose this step lightly or to be regularly employed. I believe we've been proceeding with appropriate care at each step of the way so as to carefully consider the implications of all interests at stake, the constitutional interests of the legislative and executive branches, and the interests of the American people in having a government in whose integrity they can confidently place their trust. Considering all of those interests, I believe it appropriate for us now to begin the legal process for enabling us to secure Ms. Goodling's testimony over her expected Fifth Amendment assertion. We will promptly notify the Justice Department of our application, which under the statute gives the Department a period of time from 10 to 30 days at their discretion to advise us to any possible implications that may be connected with any investigations that they may have ongoing. I emphasize that the step we are taking fully preserves all the committee's prerogatives to proceed or not as further developments warrant. If we learn something new in the course of our investigation that gives us pause, we can always stop the process before the court issues an order. And I have been working closely with and appreciate the cooperation from the ranking member, Mr. Smith. Even after this order is issued, it does not take effect unless we use it to compel testimony from Ms. Goodling over her Fifth Amendment assertion. And I once again assure everyone on this committee that we will not take that step until and unless it appears, considering all factors, the appropriate step to take in the exercise of our oversight responsibility. I'm now pleased to recognize our ranking minority member, Lamar Smith, the gentleman from Texas.